about the transcripts that I got from July the 14th discovery hearing. And for y'all that do not know, we're here today to talk about the Megan Pete versus MLAGRO'S transcripts, okay? So this was on July the 14th, okay? Let's get into it. All right, so let's start off, y'all. This is 40 pages, so get you some water, get you a snack, or just walk around the house and just listen. But it's going to be very lengthy, just to let y'all know, okay? All right, page 1. We're going to start off on page 1. This is just going over everybody's name and the plaintiff, defendant, transcribed by. Let's go to page 2. All right, let's get started, y'all. Call to the order of the court. Courtroom deputy. All rise. The United States District Court for the Southern District of Florida is now in session with the Honorable Lisette M. Reed presiding. The court. Good morning. Please be seated. Mr. Humphrey. Good morning. The court. Okay. So we are here to discuss some discovery issues in the Megan Pete versus MLAGRO'S Elizabeth Cooper case number 24-24228. Let's start with appearances from counsel. Plaintiff first. Mr. Humphrey. Good morning, Your Honor. Dan Humphrey and my colleague David Walsh on behalf of Miss Megan. The court. Okay, very good. Mr. McLemeth. Good morning, Judge. Jeremy McLemeth on the behalf of the defendant, MLAGRO'S Cooper. The court. All right. Tell me your name again, sir. Mr. McLemeth. Jeremy McLemeth. The court. All right. You are a local counsel? Mr. McLemeth. Yes, Judge. The court. All right. Very good. I think it's the plaintiff that requested this discovery hearing. I've taken a look at some of the documents. There are, it's a request for production of documents we will be talking about. Mr. Humphrey. Yes, Your Honor. There is 2 notice issues. There is really 3 notice issues. There is a request for production that went completely unanswered. It was served back in April. It's been unanswered ever since. We've received no response documents in response to that request, set of requests. And then there is also an issue of spoliation, intentional spoliation of text messages on the defendant's phone. And that leads kind of into the 3rd request in the notice, which is a request for sanctions, which we think are not even proper, but prudent in this situation. So I can get right into it if Your Honor has any questions before I start. The court. Yeah, I noticed that there was a point in which the defendant did not have counsel. And if you could give me those dates in there so I can determine whether it was, caused by the delay, what was caused by the fact that she didn't have counsel, or was it intentional? Mr. Humphrey. Absolutely, Your Honor. So to back up, what we are really talking about here today is this app called Discord. Discord is a chat server where there is different channels that the defendant controls. She posts on them. She responds to comments. She can delete users, include users, what have you. Now, back in April of this year, we served our 3rd request for production. That was back when she was represented by counsel, Mr. Hayden and Mr. Pansier. And they subsequently left on May the 27th. The court. Okay, Mr. Humphrey. Mr. Hayden left on May the 27th. And in that email said she still has a 3rd set of productions to produce to you. Did y'all catch that part? Let's rewind that back. Mr. Hayden left on May the 27th. And in that email, he said she still has a 3rd set of productions to produce to you. That was the day that responses or objections were due. The court, I see. Mr. Humphrey, now, as a professional courtesy to Miss Cooper, and we planted this for you at the last hearing we had over Zoom, we said, Your Honor, we have an issue with this. We understand she is without counsel. We are willing, because she represented at that hearing, Your Honor, to comply with counsel. Get counsel immediately, and Mr. McLemeth and Miss Dixon appeared, I think, a day later. So we said, let's extend a professional. The court, okay, Mr. Humphrey. Your Honor, the day after they appeared, we got on the phone with Mr. McLemeth and Miss Dixon and said, we're still missing this third request for production. The court, okay, Mr. Humphrey. We forwarded them the request. We told them again on June the 20th. So now, 14 days, 2 weeks after they've appeared, we've said we need these requests for production. These are critical to our case. Miss Dixon responded and said she needed a couple of days because it was her birthday, the 23rd, the 24th, and the 25th. They would get us a response on the 25th because she needed 2 days to celebrate her birthday. Okay. So we're talking about Miss Dixon, Miss Rhonda Dixon. She had a birthday and she wanted some time to celebrate her birthday, and that she would get with the Cooper about this third request of production. All right, let's continue. On the 25th, we received no response. So the 27th, we followed up, and these are in the hearing binder that we sent to you, Honor. The 27th, we responded and said, we still don't have this third request for production. They never responded. They said there's a ton of documents in this case. We couldn't possibly get up to speed this quickly. And we said, no. We need these third requests for production, these Discord files. And the defendant has produced one screenshot that I'm going to introduce. It's pretty graphic, so I put a sticky note. I want you to see the one screenshot that she served from this Discord server that proves there is responsive critical evidence on that server. Did y'all motherfucking hear? Excuse my language, but did y'all hear that? Did y'all hear that? Okay. Let's go back again. These Discord files, and the defendant has produced it. One screenshot that I'm going to introduce. It's pretty graphic, so I put a sticky note on it. But I want you to see the one screenshot that she served from this Discord server that proves there is responsive critical evidence on that server. To this day, they have never responded or told us why they haven't produced any production from this Discord server. So our ask to you, Your Honor, is to order the defendant, well, one, that all of her objections are waived, because this is way untimely, way overdue, and the law in this district and in this circuit is overdue objections or no objections at all. And two, to order her to turn over her credentials to this Discord server in the third party neutral that we've already engaged with her forensic cell phone examination, so that they can collect and produce all the responsive documents. We already have a third party neutral document review team in place who is trained on all the relevant issues in this case. And honestly, Your Honor, time is of the essence. The defendant's deposition, which we now rescheduled 3 times. Oh, I didn't know this. I didn't know this, T. Hold up. I knew of June the 4th. She's supposed to had June the 4th deposition, which then got moved to July. That is 3 times. Okay, well, for y'all, if y'all do not know, June the 4th was supposed to have been the original date for the actual deposition, which then got moved to July the 1st. And then the 3rd time it got moved to July the 21st. So deposition will be next Monday. Okay, so let's continue. The defendant's deposition, with which we now rescheduled 3 times. Once with Your Honor in the last hearing, her deposition is set for next week on the 21st. The court, okay, Mr. Humphrey. Discovery, fact discovery, and cutoff is August the 1st. Less than 3 weeks. Your Honor, we don't have time at this point to allow her to try and self-collect and self-preserve and turn over what she thinks is responsible. So that's kind of the first issue. Okay, Mr. Humphrey. And I can take a break there if Your Honor has any questions, or I can go right ahead on the second issue. The court. Well, let me start with hearing from Mr. McLemeth on why these documents have not been produced. All right, y'all, we're finna get into Mr. McLemeth. If y'all don't know who Mr. McLemeth is, Mr. McLemeth is her local counsel there in Florida. All right. So let's get into him. Mr. McLemeth, good morning again. I just want to go through a brief timeline of this situation. The 3rd request for production that was sent out was served on the defendant in April 27 of 2025. At that point in time, Mr. Milagro Cooper had counsel. Shortly after that, or maybe less than a month after that, counsel no longer was present, withdrew from the case. It says the court allowed that, and Ms. Cooper was representing herself pro se. I myself did not get into this case until June the 5th. That's when I filed my notice of appearance. At the time that I filed the notice of appearance, my understanding was that I was just going to be admitting someone for pro hac vice purposes. That changed quickly. And now I'm actually involved in this case more than I thought I would be. Did y'all hear that? Did you hear it? So let's go back just briefly. I myself did not get into this case until June the 5th. That's when I filed my notice of appearance. At the time that I filed the notice of appearance, my understanding was that I was just going to be admitting someone for pro hac vice purposes. That changed quickly, and now I'm actually involved in this case more than I thought I would be. So it sounds like someone was lying. Someone was, in my opinion, does that sound like someone was being dishonest with the purposes that someone asked for? In my opinion, that's my humble opinion, right? Okay, let's continue. That changed quickly, and now I am actually involved in this case more than I thought I would be. I got into the case. The day after I got into the case, yes, we did have a phone conversation about a bunch of different issues, discovery issues and deposition issues and whatnot. And I tried my best to keep up and to catch up with this case because there is a lot of moving pieces. Discord in and of itself is something to kind of learn because it's I don't want to say new, but it's a never sort of app. It's a newer sort of app. Discord app, and the things that they're asking for in the Discord app, they're not so easy that you can go into the app and press a button and all of the information just appears in a, the court. My understanding is what they're asking for is her login credential limits. That's what they're asking for now. The actual request for production itself doesn't ask for the login credentials. It asks, it is 25 different requests that ask for a bunch of different documents that may be relevant to what they're seeking in this case. Court. Okay, that's fair. So they never, so when did they first say, oh, well, just take the credentials. When was that, Mr. McLemmons? I think the first time they asked for that may have been June the 20th, I believe. Am I correct on that? The credentials themselves, Mr. Humphrey? I don't think that's accurate, Your Honor, Mr. McLemmons. I'm sorry, it's May the 20th. They asked in a deficiency letter. Like I said, this is before I got on the case. The court. Oh, even before you got on, they were saying, I'd like you to just give us the credentials. Crosstalk. The court. Okay, Mr. McLemmons. I think she might have been like about to get off. The previous lawyer was about to get off the case. I think he withdrew on the 24th, or the order was granted on the 24th. But on May the 20th, there was a deficiency letter that asked for, in lieu of the documents, I guess, that they requested. They were asking for her login credentials to Discord, which would give them everything that she has on Discord, which is things that aren't relevant to this case. The court, right. But when would have gone to third-party document review company? I think FTI or something like that. Mr. McLemmons. FTI, I believe. Your Honor, if I could just jump in there. This is Mr. Humphrey speaking at this point. We never asked to receive the credentials personally. We asked her to send the credentials to FTI. We didn't want the credentials. We don't want her credentials. The court. Right. I understand. Okay. Mr. McLemmons. So what we've done since getting on the case is try to catch up, but also with the documents that they're actually requesting. Ms. Cooper did submit a request to this court to give her a metadata for the Discord app. All right. We are also engaging an expert of our own so that he can go through and pull out what the defense is asking for from the Discord app itself, because Ms. Cooper does not want to give up her login credentials, not to the defendant, but to any third party. This is a third party that was contracted by the defense in this case. And so Ms. Cooper doesn't want to just give up full scale her login credentials to Discord. Discord is something that we make. Well, hold on. Let me rewind that back. Discord is something that she makes a livelihood off of. She's a streamer. She uses Discord along with other apps to produce a livelihood and income for herself. She doesn't want to give up her credentials for the app, the entire app. So we're trying our best to make sure we can get those documents, but they did ask for it. They asked for 25 different requests, and each request asked for several different types of documents that would be found or possibly found on the Discord app. Court. So when will she have the response ready? Mr. McLemmons. We just got the metadata, I think Friday, and I would anticipate we could turn that order, the relevant portions of it, in this week. The expert, we have a meeting with him this week as well, and if he can get access to it and get us what we need, which he does work pretty quickly, then I would say by the end of the next week, the court. The end of next week, Mr. McLemmons. Yes, the court. But the deposition is not the end of next week. When is the deposition? The 21st? Mr. Humphrey. It's on Monday, Your Honor, a week from today. The court. Okay, so that's not going to work. I mean, this is Mr. McLemmons at this point. I mean, if the defense is able to, but because I'm going to California for the deposition, there is one on the 21st and there is one on the 29th on the 30th. If the defense is able to move the deposition of Ms. Cooper to the 29th, I can be out there and attend both of those depositions, the 29th and the 30th. And that gives them more time to go through anything that we produce. The court. Didn't meet and confer before you came to this hearing? Mr. Humphrey. Judge, we attempted to meet and confer ad nauseum. Well, he said, we have been trying to meet and confer. We sent several emails, several letters. They wouldn't pick up the phone to talk to us. Did y'all hear that? The court. Okay, Mr. McLemeth. They have not called me and I have not picked up the phone. That is not true. The court. Okay, that may have been California counsel. So let's back up here. You have someone, Mr. McLemeth, who is an expert, who is going to be getting the documents off of Discord that are being requested here, Mr. McLemeth. Yes, the court. But he doesn't have a whole week to do it because there is a deposition on Monday. So if he has that, does he have it now? Whoever this expert is, Mr. McLemeth, does he have what? The court. The expert. Does he have the login information, and is the expert working on getting this document request, Mr. McLemeth? So we engaged him last week. Today, we are supposed to have a meeting with him to give him everything that he needs to do the work. In my experience, you know, doing criminal cases, he works pretty quickly. He can PDF things that I usually use this platform where I get discovery through a platform, a cell phone platform called Celebrate. Able to go in there and pull documents for whatever he needs and put them in a PDF format, which I think would be the proper format to give the defense counsel. Mr. Humphrey, judge, respectfully, can I be heard? The court, not yet. Of course, but you will be heard. Mr. Humphrey, yes, Your Honor. The court, I just want to make sure that I understand exactly what you are presenting to me, Mr. McLemeth. So pretty quickly, we don't have a deadline other than it will take him a whole week and he will put it on a PDF, Mr. McLemeth. Well, so they're asking for the videos as well. And some of those videos issued, let's say the first request of production and the third request, it asks for documents and communications related to a live stream. This live stream, the way that it works is there was an interview conducted by two individuals. Okay, oh, this might be T, y'all. Hold on. There was an interview conducted by two individuals who have really nothing to do with this case on YouTube. And Ms. Cooper just took that YouTube video and streamed it, brought it over to our Discord. Once the live stream is done, there is nothing else. The video itself disappears. What they're asking for, and I don't know if this is what I forgot to mention, but if they are asking for the video itself, the video is gone. So the documents, the court interrupts. But the source of where she got the video, which is YouTube, Mr. McLemeth, that would be there. Yes, the court. I see. Okay, all right. So it doesn't sound like that's going to work. What you have planned, because we now have the deposition set for Monday, and you are just about to meet with this individual that is your expert, and your documents are already at least 2 weeks after the deadline, right? So it doesn't sound like a practical plan. This case is have some deadlines that are going to be strict. You know, in federal court, you know, in federal court, y'all heard this part, right? In federal court, it is, and I can't expect the plaintiff to be left scrambling at the end of that deadline to comply, right? So it seems to me that most practical way to deal with this right now is to, as plaintiff has requested, give that login information to third-party FTI so that they are able to use the week to prepare to review the documents, in between you and the plaintiff's counsel, determine exactly what or which documents comply with this request. That's what's going to make sense, I think, at this point. There is a confidentiality agreement in place. There is, Your Honor, the court. Okay, so that should protect her. And then I'm sure going forward, just like any other login information, She could change her login credentials so that anything that she puts in after the time she turns it in would not be available to the FTI or anyone else, unless there is something else I don't understand about Discord. There may be things I don't understand about Discord, but that's usually how login credentials work. Mr. McLemon, Your Honor, I would agree that portion, I don't know, or if FTI has ways to do other things, that's beyond my pay grade. Mr. McLemon. Right. Well, my concern is, and I understand that you got into the case lately and that your authority on the case seems to have blossomed, whether you like it or not, but it's just not timely. What you are planning to do is not workable considering the deadlines that we have. What else should we look at? Mr. Humphrey. Yes, Your Honor. There is a notice issue about spoliation of text messages. I can continue from back here or come to the podium, Your Honor. The court. Yes, I would like to hear that issue as well. Thank you, Mr. McLemon. I really appreciate your information here, Mr. Humphrey. So, Your Honor, the second issue is about spoliation of evidence, specifically text messages on the defendant's phone. Now, you just heard Mr. McLemon say that there has been evidence that has been deleted from the Discord server. He just stood at the podium and told you that. Mr. McLemon, I didn't say that. The court, excuse me, he didn't say that. Mr. Humphrey, well, he said that the video that was on the Discord server is no longer on there. The court, right. But he didn't say it's deleted. There may be things we don't understand about Discord. That's not what he said. Mr. Humphrey, what would we do now? Well, what we do know is there were text messages deleted from the defendant's phone. And we know that those text messages was deleted after. Some of those text messages was deleted specifically, the court. Were these text messages from Discord? Mr. Humphrey, no, regular iMessages, SMS. Mr. Humphrey, to back up, Your Honor, as you know, defendant tried to produce screenshots of text messages way in the beginning of this case. We met with Mr. Pensier and Mr. Hayden when they were still counsel of record and said, these aren't sufficient. We need to see the metadata. We need to see if there were text messages deleted, if there were text messages before and after this. So we agreed with Mr. Pensier and Mr. Hayden, and presumably they have their clients consent to this, to the third-party neutral FTI, who is a leading expert in forensic collections and that kind of thing. Take her cell phone and have the third-party attorney review team, a clean team, if you will, review all those text messages and produce to us the relevant response date data. Now, when they did that, they alerted both sets of counsel that there were seeing large swaths of text messages deleted on 3 very specific points in time. Did y'all hear me? Did y'all hear me? Let's go back, y'all. Now, when they did that, they alerted both sets of counsel that they were seeing large swaths of text messages deleted on 3 very specific points in time. Now, to be clear, these were text messages that were received or sent on 3 specific points in time. And this is tab B of your binder, Your Honor. The court, Mr. Humphrey. So this is the letter that we sent on July the 8th to opposing counsel. Turn to the 3rd page on October the 5th and 6th of 2022. T, this is T, y'all. Miss Cooper, y'all ready? Miss Cooper deleted 1,716 messages or attachments that she received or sent on that day. Now, that's critical because that's just before Tory Lanez's criminal trial against Miss Pete, which was what her statements are about in this case. This precisely also matches a significant gap in text messages with Mr. Lange's father. Oh. And you have a third party neutral saying this couldn't have occurred. Then July the 29th and July the 30th, 2024, recently, she deleted 2,613 messages. Oh, I got that. Oh, this is juicy. Did y'all hear me? That was juicy. All right, y'all, let's continue. That's exactly when she was making public statements about Miss Pete that are at the center of this case and her alleged mental capacity. And then August the 10th through August the 12th of 2024, Miss Cooper deleted 1,896 messages. When she accused Miss Pete, quote unquote, of trying to deceive the court again. Now, this is blank spoliation. Now, what FTI also told us was that they can see messages were deleted between the time we filed this lawsuit and the time she handed over the device to them. And I'm not talking about a couple of messages here and there, Your Honor. This was 20,000 text messages that were sent out or received since the inception of this case and to the time she turned over her cell phone. 1,000 text messages. But there is more to it than just that, Your Honor. FTI can see, and defense counsel conceded in their letter to you this morning that Miss Cooper deleted WhatsApp after this case was ongoing. The forensics report, which is in your binder, Judge, on tab B, Exhibit 2. If you turn to the last page, the conclusion page, Your Honor, page 5. Bullet point says, evidence was identified that WhatsApp was communicating over the Wi-Fi network between July the 4th, 2023 and March the 18th of 2025. That means WhatsApp was on her phone on March the 18th, 2025, communicating over the cell phone network. Did you hear me? Ooh, excuse me. The court. And this case was filed when? October the 3rd, 2024. The court. Okay. So, for a substantial period of time, as this case was ongoing, WhatsApp was on her phone. But when she turned it over, and this is the last bullet point, Your Honor, when she turned it over to FTI on April the 9th, WhatsApp was no longer on her phone. Sorry, that's the first bullet point, not the last point, bullet point. I mean, that's spoliation, Your Honor. And when we know there is responsive critical evidence on that WhatsApp device before, because she produced some documents from it, but she selectively produced what she wanted to produce and not the whole system. The court. Okay, so is there some way to get that information? Humphrey. FTI is the court. Not from her phone, I understand, but from WhatsApp, Mr. Humphrey. From WhatsApp, we're not sure because we don't know what she has or hasn't deleted from WhatsApp. On text messages, the thousands of messages, there is no way to recover those messages. So we prepared a proposed order that we'd like to share with the court with an adverse inference that we think is appropriate in this matter. Can we approach the court with that and show that the opposing counsel, if your honor would like? The court. Okay, so let me make sure I understand it. So there's text messages, just regular text messages that have been deleted, and according to FTI, there is no way to restore those. Correct, judge. The court. I'm sorry. There are WhatsApp messages, and perhaps they have been retrieved from WhatsApp, Mr. Humphrey. If they have the credentials, they can tell whether or not they could be retrieved. Or FTI could tell, Mr. Humphrey. If they have the credentials to her WhatsApp, the court, okay, so we need to find out about that, okay? What's the adverse inference you would like the court to conclude, Mr. Humphrey? If I could, the court, yes. Have you shown this draft to opposing counsel, Mr. Humphrey? We have not shown this draft to opposing counsel, but I can show it to him right now. The court, please, Mr. Humphrey, may I approach? The court, yes, you can give that to Betty. Thank you very much, Mr. Humphrey. It's on the second page, starting with paragraph 3, Your Honor. You can see the case law that we pulled this from. And in fact, in these two cases, which these two cases were provided in the letter that we sent to the opposing counsel, I would say it wasn't even as bad as it is in this case. The two cases were company cell phones handed over, and then the company wiped the cell phones. This is the actual defendant wiping her own cell phone, the court. So subsection D, in reaching your verdict, you should assume and infer that the documents that defendant deleted would have shown that the statements about plaintiff that are at issue in this case were false, and that defendant either knew them to be false when she made them or had serious doubts about whether they were true when she made them. Yes, Your Honor, the court. So that's the jury's instructions that you would like the court to give the trial. What did I tell? Well, for some of y'all, let's pause right here real quick. Anytime that there is an act of spoliation, there is always a situation where they will give direction to the jury and let them know that when it comes down to the case, it would be a situation where they deleted and called spoliation that could have very well pleaded them innocent if they were innocent, but it just shows everything to assume that they are guilty of the acts that's being brought upon in front of that jury. So he's already trying to submit, let me correct myself. He's already trying to submit jury instructions. Okay, let's continue. I see, Mr. Humphrey. I mean, this isn't a couple of text messages missing, Your Honor. This is thousands upon thousands upon thousands of messages. And we know that she deleted at least 20,000 since the inception of this case. The court. All right, let me hear from Mr. McLemeth on this issue. Mr. McLemeth. All right. Whew. All right. So in this situation, the plaintiffs are alleging that Ms. Cooper deleted these text messages because they had something to do with this case, and she is concealing information about, I guess, this case or her liability as it relates to the claims that are against her. The court. That's what they're saying. Yes, Mr. McLemeth. Without any evidence that this is actually what is happening here, that there is an intent on her part to delete these messages for this purpose. I mean, I don't know whether she normally delete messages in this matter. I don't know if these are threads that she's deleting, like going into the thread and deleting the entire thread, or going one message by one message to delete them intentionally. I think that this issue should probably be revisited after her deposition. During her deposition, they can ask her questions about whether and why she deleted these messages. And with actual proof, sworn testimony, then we can revisit whether she intentionally deleted messages for the purposes of hindering the plaintiff or the court from getting the truth of the matter in this case. The jury instruction here that reads, in reaching your verdict, you should assume and infer the documents that defendant deleted would have shown that are statements about plaintiff, etc., etc. I think that's too strong of an instruction. The word can, I think if it does get into the point where the court is going to implement that jury instruction, the word can instead of should is more appropriate, because the way that it's written now is basically the case will be over and that's handed to the jury, and the jury hears an instruction from the judge that they should assume and infer that the documents met a particular element of this case, of the claim in the situation. And that would pretty much be taking the case out of the hands of the jury and telling them how they should find or a particular party in this case. So without actually having proof that it's what is happening, I think that, that out of the 20,000 messages that they are claiming were deleted, I don't know if even one of them, maybe 10 of them, have any relevance to this case. And if they can be retrieved, and if they are WhatsApp messages that can be retrieved, I think that would rectify this issue and the jury instruction shouldn't go forward. So I think it's a premature ask for the plaintiffs to insert this jury instruction in this case, whether it's for summary judgment or for the trial purposes, and they can ask whether they need to ask her in her deposition about this. The court. All right. Thank you very much. Counsel, why can't we at least postpone that until have you an opportunity to question her about these deletions? Also, I would like to get more information about the deletions, right? I mean, it's important to me to understand that what came before the deletions and what comes after, right? So that I can put what you are asking into context. Let's say what came before the deletion was something that had to do with a health issue that she has that may not want to be out there in the world, or something else having to do with a relative. Then I can see how a person might then, being a layperson, think, or I should take those out because they are private. But if the text messages right before the deletion say about the case, about the situation we are talking about, Miss P, well, of course, I see your point. So I need more context, Mr. Humphrey. Absolutely, Your Honor. And I can provide those texts because FTI, the forensic third party neutral, has given us these contexts. They know these are not at variant deletions. The court. Is that here in the book, Mr. Humphrey? That is, I believe, in the email. So I have a copy of the email. If I could approach, Your Honor, this is where they flagged for both counsel the issues, and opposing counsel that has seen this. We sent this to them, Mr. McLemeth. I don't know which email you're referring to, Mr. Humphrey. So this is an email from, I'm just trying to find it. We have an email from FTI where they say that these text messages were deleted on very specific dates. And in the spreadsheet that we provided, Your Honor, and the courtesy copy, if you expand that spreadsheet, it shows you where all the missing text messages are. We know that those weren't inadvertent or subject to some retention policy, because there are text messages immediately the day before and immediately the day after. The court. About what, Mr. Humphrey? That I don't know off the top of my head, Your Honor, but we do know that there are missing text messages between the defendant and not only Mr. Lang's father, but defendant admits that there are missing text messages between her and Mr. Lang's informal discovery responses. So it seems that they're referring to Mr. Lang's, if y'all do not remember, when they were trying to do discovery, and then they tried to deposition Tory Lanez and stuff like that. I'm not sure, but let's keep reading, y'all. Let's keep reading. So these are critical pieces of evidence because, as Your Honor knows, one of our theories in this case is that the defendant is a paid mouthpiece for Mr. Lanez to avoid the orders that are preventing him from saying these things himself. So that is critical to our theme and theory of this case. The court, right, Mr. Humphrey. And that's critical evidence. And FTI has said there are text messages the day before, there are text messages the day after. These large swaths of text messages couldn't have been due to retention settings or inadvertent. And not for nothing, Your Honor, the defendant is a technological savvy woman. Oh.
Yeah. What's the fucking procedure when you got a gun in your hand?
Do y'all understand what I'm saying? Let's repeat that. Let's repeat that real quick. And not for nothing, Your Honor, the defendant is a technological savvy woman. She streams 5 to 6 hours every single day. Is that diabolical? My God, today. Damn. Let's repeat that. She streams 5 to 6 hours every single day across 5 platforms simultaneously. She runs the Discord server. And counsel has said that's how she makes her living. That's her business. So it's just not conceivable at this point in this case that these were inadvertent productions, and not for anything, Your Honor. Back in February of 2022, the defendant said on a tweet, and we have this tweet here that we can provide, Your Honor, that there is pieces of the evidence in the Tory Lanez trial that she doesn't believe. And if anybody disagrees, they can sue her. A lot of times you just need to shut the flying fuck up at point in time, because what you text or what you say could be used against you in a court of law. And you told this woman to sue you, and that's what she did. And they got the message to say you said evidence in the Tory Lanez trial that she doesn't believe, and if anybody disagrees, they can sue her. Okay, let's continue. So as of February 2022, she's on notice that somebody could sue her about her statements regarding Miss Pete and the criminal trial of Mr. Lanez. I mean, court. Okay, Mr. Humphrey. I mean, Your Honor, we have been at this for months and months and months. We have met roadblock after roadblock with counsel recusing, counsel withdrawing, new counsel saying they need time to get up to speed. They need time to get up to speed. We're barreling toward the fact discovery deadline and the trial date in November, Your Honor. My client wants to go to trial in this case. She wants the truth told. So he's saying Megan Thee Stallion, y'all hear it, y'all. Megan Thee Stallion is ready for the trial to start. She wants the truth to be told. Okay, let's continue. The court. So if I understand what you're saying correctly, you have from FTI the series of text between the defendant and Tory Lanez is the person that was, there's a lot of Tory Lanez here, sorry, Mr. Humphrey. There's a lot of Lanez here. So Tory Lanez is the criminal defendant who shot Miss P. All right. All right, let's continue. The criminal defendant. There are text messages missing right after when you know that they're actually communicating with each other, Mr. Humphrey. So I'm not sure if the text messages that they see on the cell phone are with Mr. Lanez or if they're with somebody else. I'm not sure about that, Your Honor. I know that there are text messages on the cell phone, but like Mr. McLemeth said, which it struck me as odd that he said, we don't know what happened to these text messages. The first thing I would have done, Your Honor, was ask my client what happened with these text messages, especially when I knew it was a notice hearing in front of Your Honor. So the fact that he doesn't know kind of strikes me as maybe there probably was some bad faith there. The court. Well, here's the thing then. I think you're going to have an opportunity to ask her directly those questions on Monday, Mr. Humphreys. Okay, the court. Those answers will give you, if you are correct, even further evidence to come before the court to get this type of instruction, Mr. Humphrey. Yeah, the court. So I think that this is something that, and we still will have time to deal with that issue. So after that deposition on Monday, if you think that you have the evidence to come back, you should do so. Contact Chambers. We will have a hearing on it again. And if give you the opportunity also to give me the context for those missing texts so that I have what I need to make such a strong jury instruction. Mr. Humphrey, Your Honor, could I make a suggestion? The court. Yes, Mr. Humphreys. Perhaps it would be burdened to set get it out. Ooh, tongue-tied. Evidentiary hearing where we would have FTI come in. We could have the defendant come in if she'd like, or if opposing counsel thinks it's appropriate for her to testify, and we could give you all of the evidence. Oh, y'all listening? The court. That would be perfect. Do y'all not recall? They wanted on the 15th. Because let me pause real quick. If y'all do not recall the court document that I had put out, they gave her from the 14th to the 15th to provide the passwords to Discord. So we're getting into that conversation right now. All right. So let's continue. Mr. Humphrey. And we would do that on a date determined today or tomorrow for a future date, that so that we are keeping this case on track. And we are keeping this case moving forward because we do have a very quickly approaching deadline. So I think that might be a reasonable solution here. The court. I think that sounds like a good idea. So we'll do that, okay? If you will contact us on Monday, I'm sure we can set up an evidentiary hearing quite quickly. Humphrey. Absolutely, Your Honor. And then the third, the court, after Monday, Mr. Humphrey. The third notice issue, Your Honor. The rules require that when you have to come before the court on discovery issues like this, that fee shifting is appropriate unless there is good cause. Nothing that I heard from opposing counsel or the email that they sent at 2 a.m. suggests good cause. The court. And what would you suggest is the amount fees for this? Your Honor, this is Mr. Humphreys. I think we could work that out between ourselves. If Your Honor orders entitlement to fees, we can have a discussion with counsel, work that out ourselves. And if not, the proposed order I gave you has language that says we will meet and confer within 5 days. We can't. We will submit our bills to the court, and then you can determine what's appropriate. The court. Okay. I think that's appropriate that there should be a meet and confer on the attorney fees. Mr. McLemmons. Anything you want to add? Mr. McLemmons. Judge, I think they did a typo. That probably was the court asking it. Mr. McLemmons. Judge, I know plaintiff's counsel is saying that there is no good cause for these issues on this case, but when these discovery requests were sent out, time from when the discovery request was due, Miss Cooper was either y'all listening? Miss Cooper was either falling out with her attorney or her attorney was getting ready to withdraw, and you know he did withdraw. So by the time this deadline came, she had no counsel, and then it took a week or so for her to get counsel. I got on this case on June the 5th, and since then, I've had to try to get up to speed with this case, try to get up to speed with this court. There are 25 requests for production just for this one request for production. In this case, there is a previous counsel, Michael Hayden, who does not really respond to any messages. Now, if y'all don't know who Mr. Hayden is from Unite the People. Okay. So not only, let's pause here. When we had the Zoom call for the Discovery Status Conference, if some of y'all that were there, I was there. When it came down to them actually going over, if y'all do not recall, there was 17 documents that was only for attorney eyes only that they were trying to get the courts to send out a letter of contempt for either Hayden and Pansier to answer, because once it went to Milagro Elizabeth Cooper going pro hac vice or pro se, because she had to represent herself at that point when she didn't have counsel, they were trying to figure out where did those documents go, because we need them back. It was attorney eyes only. We want to make sure that this did not get in the hands of Milagro Elizabeth Cooper. Okay. Let's continue. Mr. Hayden who does not really respond to any messages, emails, phone calls, or anything like that for him to help us get up to speed with what was done in this case and what was not done. And then, I mean, we're moving the case along. We're setting depositions and we're trying to get these things done. So it's not as if we just sat and didn't do anything. The court understood, Mr. McLemeth, and I don't, the court. So no attorney fees should occur from the time in which Ms. Cooper had no attorney, Mr. Humphrey. Okay, the court. I understand that there is some time that she had an attorney before, but she didn't have an attorney essentially for about a month, Mr. Humphreys. I think it was a little bit less than that, Your Honor. The withdrawal was on May the 27th, and then we were before Your Honor on June the 4th, and then they appeared on June. Okay, and be aware, counsel, that the attorney fees are going to have to give new counsel some time to get up to speed, Mr. Humphreys. Absolutely, the court. So you should have consideration for that, but I do appreciate your concerns, Mr. Humphreys. Thank you, Your Honor. The court. All right. Anything else today, Mr. Humphreys? Your Honor, can we just get a date certain by which she has to turn over her Discord credentials to FTI? The court. Good point. Why can't that be done within the next 24 hours, Mr. McLemeth? Oh, hey, Mr. McLemeth. If the court is ordering her to turn over her credentials, then the court, it can be done in 24 hours, Mr. McLemeth. Yes, the court. I'm going to ask that that be done. The credentials will go to FTI, the third party, within 24 hours. Humphreys then chimes in and says, and the WhatsApp credentials as well, Your Honor. The court. FTI is hired to review that as well. The WhatsApp, Mr. Humphreys. Yeah, but because it was uninstalled from her phone, they would need her credentials for that, Mr. McLemeth. That works. I never put any credentials to get into WhatsApp. You have to either use a phone number or the phone itself. The court, right. It's not separate, Mr. McLemeth. I don't know that that is how that works, Mr. Humphrey. We will meet and confer and work on that, Your Honor. The court. Yeah, I think you would need to. Yeah, because I'm not sure. At this point, we don't know standing here whether it's even possible to get that information. It would maybe be something you would have to get from WhatsApp directly. So maybe all you need is perhaps an affidavit for her or something from her that could go to WhatsApp for WhatsApp to turn it over, Mr. Humphrey. Right. The court. Okay, Mr. Humphrey. Thank you, Your Honor. And if Your Honor wants a copy of the proposed order that we sent you on Word doc, it's got the court. go ahead and please send that to the chamber's email on Word doc, and we will make some edits to it, and it can reflect the court's ruling today. Mr. Humphrey. All right. Thank you, Your Honor. The court. All right. Thank you so much. The court security officer. All rise. Court is in recess. Proceedings were concluded. And that is the end of the transcripts. So what key things did y'all take from this actual transcripts? There were over 20,000 text messages deleted. That was deleted. She did not give up her Discord after the third attempt, which we do now know after the 14th. They gave her 24 hours to hand that over. So we do know that, okay? And as always, like I always say to y'all, when you lead with integrity, you never ever have to worry about somebody questioning your loyalty or your intentions. Trust nobody. All right? Now, if y'all do not know, as of right now, court that was had on the 14th was in the federal wing. Okay? It was not accessible to the public. However, I was able to get my hands on the transcripts. Okay? So I hope y'all enjoyed yourselves today and enjoy the rest of y'all's night. We'll convene when it comes down to this court case. I will be staying tuned. I will give y'all updates about this. And when it comes down to the actual trial, the trial will be on November the 17th. Since the date was moved from September the 8th to November the 17th, I am unable to go due to it being the holidays. And I really cannot go on vacation during the holidays. But if it was still September the 8th, I would have been there, and reporting to all of y'all. But I do appreciate y'all for joining me this lovely evening, and I hope y'all have a great night. And I will save this, okay? So if y'all need to go back to it for reference, I will have it on my platform. But any updates that comes out, I will let y'all know, okay? But until then, I want y'all to have a great evening. Get y'all something good to eat. Get you a good movie and rock out, y'all. All right. Bye-bye.